Necessity is the mother of invention, and my inability to see the puny writing up there has caused a change in where I'm going to deliver these remarks so that I can stare at my own slides at the very least. Thanks for coming out, and I want to thank our panelists who got no introduction and need no introduction. They are sitting in the order in which they're going to give commentary. This paper, and I'm going to toggle over to this paper, is co-authored with Professor Lund and myself. It is titled, Should Corporate Law Go Private? Those of you who have been following corporate law debates over the last couple of years know that they have become incredibly freighted, and in particular, we are sort of in this sort of, it's actually from an academic's perspective, it's an interesting renaissance of this idea of regulatory competition, this sort of race to kind of figure out what state is going to sort of prevail in this kind of dance-off to try to attract new incorporations. This race for many, many decades, having been seeded from basically New Jersey to Delaware, something that Sarath has written about, has pretty much been owned by Delaware. It still, quite honestly, is owned by Delaware, but there's at least more vibes in the water supply about other states competing. And in some ways, that has sort of got folded into the most recent the most recent amendments that we have seen in Delaware law. SB 21 has gotten a lot of the attention. We're actually going to be talking about largely a different one that we think got buried in the lead of SB 21, which is one that happened just before. This debate, many of you know, it's a pedigree debate. Is this a race to the top where states try to outcompete each other for provision of quality corporate law? Is it a race to the bottom where states try to compete to try to just get CEOs and senior management to come incorporate there and may be representing some form of agency cost? Is it kind of a weird race that's not necessarily to the top or the bottom, one that is definitely mediated by all types of network effects and so forth? You can find proponents of every one of these positions now and going back several years. Our enterprise in this paper is in part to engage in this debate, but it's also in part to kind of think about, like, in this moment that we find ourselves, are there interesting new opportunities in forms of regulatory competition that some of the recent statutory innovations have given rise to? And we think that there are. So the basic paper, and I'm actually not going to cover the first two parts of this paper because I wanted, Dorothy and I wanted our panelists to focus on the third, the more sort of constructive part that we think kind of deserves to have its tires kicked a little bit. The first part basically says, look, if you're thinking about regulatory competition, it is important to stay away from too much of a simplistic stick figure view of how competition works. Both states and consumers of corporate law, companies and shareholders, are highly heterogeneous in their views and their preferences, and it should therefore not be surprising to see a heterogeneous type of equilibrium where there's all kinds of sorting that goes out. And in fact, I think that's in some ways what we're starting to see kind of flower. We then use that, we sort of develop that model to then evaluate the 2025 reforms under SB 21. Although they were touted as a palliative against losing revenue from incorporations, we argue that the actions just don't really square with what you would predict for a revenue maximization approach. That maybe it was in a good faith attempt to do so, but that would not necessarily be the way that one would move in order to maximize or protect revenue. I can talk a little bit more about that in a bit. But what we do in this paper at the very end is to say, if Delaware possibly after a good faith effort has made at least for some companies the venue a less attractive place to incorporate, does it necessarily mean that Texas or Nevada or New York or New Hampshire or Oregon is going to move in on the action? That may be the case, or the SEC or the feds for that matter. That may be the case. But we argue that there may actually even be a more potent form of competitor, and it has nothing to do with SB 21, but it has to do with about a 6-month precursor to SB 21, which is the amendment made to Section 122 of the Delaware Code, which basically articulates what corporations are entitled to have in their defining documents, including side agreements. All right, and so our view is that while there are a lot of folks out there who are discussing the newly revitalized race in corporate law between states, we think Delaware's possibly biggest competition is from within. Those of you who grew up in the 80s might recognize that meme, right? The call is coming from inside the House. And inside the House, we view as being Delaware's new subsection to 122 that basically opens the door to wide applicability of stockholder agreements, both between stockholders and vertically between a stockholder or prospective stockholder, or many of them, and the corporation. This new statute, while you can't waive all fiduciary duties via contract, you can covenant not to assert fiduciary duties, including the company itself. And that's kind of where, in some ways, the jackpot of retrenching on fiduciary duties may take place, at least when it pertains to derivative actions. You can also impose new contractual fiduciary duties and impose a standard that is a fiduciary-like standard contractually as well. Importantly, these are also subject to the, by our account, these are subject to the Federal Arbitration Act, which creates federal preemption for the protection of an arbitration provision that would appear in this sort of context. And weirdly enough, or I guess conveniently for our approach, this provision explicitly carves itself out of Delaware Section 115, which otherwise would require that you seek a Delaware forum as judicial forum as your venue. So we actually sort of think that this may be a position where the table is ripe for almost an LLC-like governance by contract, by shareholder agreement, even though this is in the corporate setting. All right? I will not belabor the words of Section 122.18. A couple of these folks might belabor the words of Section 122.18, so we'll come back. You can toggle over to this section if you want, and I've highlighted in red some of the parts of the language that we think are going to operate in that direction. Those of you who are fans of the Federal Arbitration Act, or at least know something about it, will also know that once something is recognized under state law as a contract, the FAA actually does swoop in and, in our view, actually has jurisdiction as well. All right, so how do we think, and then I'm going to sit down, how do we think that this type of arbitration type structure could in principle displace the what we've conventionally thought of as being a state provided corporate law with a privatized version of corporate law? So we float something we call the Delaware Arbitration Board, or DAB. We haven't yet secured Usain Bolt's endorsement, but we really need to. We need to work on that, Dorothy. So here are the basic 6 elements that we think would be important if we were really going to be serious about this. And this was originally kind of started almost as a provocation, but maybe because you get committed to the paper you're writing, it becomes less and less of a provocation as you go. So it's going to be, it would be a franchised fee-based thing, almost mimicking like a new state that is entering into the corporate law competition. There would be free entry. We're not calling for a monopoly. Anyone could set up one of these things. But the key thing is that there would be an arbitral statute by which you would essentially litigate these claims. That arbitral statute would essentially apply to anyone who basically pays for a subscription to this Delaware Arbitration Board, and it would be staffed by expert adjudicators, possibly retired judges that had sat in a state that is essentially the basis for the arbitral statute. Other types of experts could sit on this as well. They would issue written opinions and would be bound by precedents. So it's almost like you are essentially setting up a shadow Chancery Court, but it's essentially administering to these contractual provisions, all right? And so that's sort of the idea, the overall idea. It still harnesses a lot of the things that we think have been beneficial about Delaware law, right? The fact that you've got clear precedents. The DAB, as we propose it, would actually adopt Delaware law as its background statute, and then the DAB itself would be responsible for amending that statute, possibly copying other amendments, possibly going its own way forward in time. So it would essentially be, we would be sort of launching this non-state, shadow state competitor. All right, a couple things about details, and I'm going to hand it over to our panelists. We spent a fair amount of time in this paper to sort of think, how would one put this together? It's the easiest to put together if you have a brand new company and you're trying to set it up under one of these under this sort of a structure. For an existing company that already has issued shares, it gets a little bit more difficult to do, right? Obviously, you have existing shareholders that bought with expectation that they weren't going to be subject to this type of a stockholder agreement. However, doesn't prevent some shareholders from signing on, or even prospective shareholders from signing on, including the corporation itself. And as a result, the corporation can covenant not to bring certain actions, or could be given other types of actions that it could bring in right of the corporation, which essentially is going to swallow up a lot of what we would think is derivative action type of activity. The one thing, and it's a winnowing classification, is what about direct actions that stockholders would bring? A non-signatory stockholder would probably not be able to be bound by the restrictive aspects of the DAB, but we propose that they be made intended beneficiaries of the benefits, and that we believe that under Delaware law, one could restrict the transfer of shares to new stockholders unless they agreed similarly to come on board. What would happen at that point is that corporate law or corporate litigation would become essentially contract litigation pursuant to an arbitration provision. The Delaware Chancery Court would still play a role, but it would really be compelling arbitration and enforcing judgments of the arbitrator. Last thing I will note is that in some respects, one of the big pressures that has been put on a lot of courts in Delaware included is sort of sniping from dissatisfied litigants when they don't get the outcome that they like. So we also propose that there be a contractual non-disparagement provision towards the arbitrators themselves through this structure. Now, this really is kind of a swing for the fences sort of approach, and we realize it. There are probably several criticisms, which is why we have basically recruited 5 critics to tell us both why we're wrong and how we might be able to be right. I will not read through these potential criticisms because I have reason to believe that our panelists are in fact going to cover them. So with that, I'm going to cede the floor over to Vice Chancellor Laster, who has...
There we go. All right. Thank you, Eric and Dorothy. I think this is a very challenging and ambitious idea, and if nothing else, it introduces some wonderful thought experiments that we can all ponder to grapple with some new issues. The last panel helpfully teased my slide title for a long time, so I know you all are eager to hear what I have to say. I'm going to focus on cases. I find that law professors don't cite a lot of cases. They cite each other because then you get your cite counts up. They cite statutes because they're short and easy to read. But when you get into actual how the law applies, you have to think about cases. The other thing that I'm going to do is I'm going to refer to these things as governance agreements. I think it's misleading to talk about them as stockholders agreements. As my friends Gabe Rauterberg and Jill Fish have shown, these are really new things. And what's new about them is they're introducing governance obligations onto the corporation. And that's different from a stockholder level allocation of rights. And so we shouldn't pretend that this isn't a new idea. All right, so let's start by looking at 122.18 briefly and its exemption of governance agreements from section 115. 115 is Delaware's provision that doesn't let you give exclusive jurisdiction to any other state. It requires that you allow internal affairs claims to be litigated in Delaware. Now, this was introduced not only to prevent people from going exclusively to other states, but also to implicitly negate arbitration, because the Federal Arbitration Act says that you judge an arbitration provision based on how you would approach any other contract. And so by eliminating broadly the ability to exclude Delaware for any contract, any other forum, the idea was we're not singling out arbitration. Note, though, that this only applies to internal corporate claims, which is the defined concept. So if you do not fall within the definition of internal corporate claims, you are not restricted by 115. So under Shabakuki, there is a whole new arena of intra-corporate claims that you could potentially already send to arbitration or to another jurisdiction. Not to mention the possibility, the extent that bleeds into some type of external claims. We still don't know how far Shabakuki goes, right? But if you are in the world of internal corporate claims, 115 says that you cannot divest the Delaware courts of jurisdiction over that. But then we get 122.18, and 122.18 says you can. You can't go beyond what the state requires except for 115. So that's what opens up the possibility of sending some types of claims at least to arbitration, as Eric and Dorothy are contemplating. So let's talk about a basic arbitration provision. This is the type of thing that you'd see in basically any contract. The first sentence is mandatory. Any dispute must be determined by final and binding arbitration. Then you define a dispute. Sometimes it's not separately defined. The key terms are generally the prepositions arising out of, relating to, in connection with. Arising out of is usually construed to mean under the agreement, so a breach of contract claim, although it can be a little broader. Relating to extends, in connection to extends, and then you have a list of types of things that to make sure we pick it up. Not only this agreement, but it's also formation, etc. So that's a standard type of arbitration clause that you will see. So does a basic arbitration clause like this cover breach of fiduciary duty claims? Well, we have case law on that. And the leading case is a case called Parfee. This case involved an underwriting agreement. The parties wanted to challenge breaches of fiduciary duty in connection with the transactions that gave rise to the issuance. The defendants invoked the underwriting agreement and the arbitration clause in there, and they said, send it all to arbitration. Then Vice Chancellor Strine said, you got it. He said, it doesn't make any sense to split these types of claims. They're all from a common nucleus of fact. You send the contract claims to arbitration, and you send the breach of fiduciary duty claims to arbitration. Then it went up on appeal. Not so fast, said the Delaware Supreme Court. The Delaware Supreme Court drew a distinction between claims that arise under the agreement, which are subject to the arbitration clause, and claims with an independent source. And these independent source claims didn't arise from the agreement. The fiduciary duty claims arose from the Delaware common law. They arose from the concept of the corporation. And so without something to expressly bring them into the agreement, such as explicit language, they were outside of it. So no, you don't arbitrate those claims. And what we got out of that was two concepts. The first, a broad versus narrow clause. When it's broad, you have to think about this stuff. When it's narrow, you just apply the plain meaning. But then we also got the concept that some agreements, although generally speaking you can't arbitrate automatically existing fiduciary duties, if the agreement itself gives rise to the fiduciary duties, then the arbitration provision applies. So in a case like Elf Outachem, where it's a question of fiduciary duties under an LLC agreement, the LLC agreement gives rise to the fiduciary duties in the first place, and so an arbitration provision in that agreement covers the fiduciary duty claims already. All right. So how do we operationalize this for our purposes? After Parfee, this has been operationalized as you might expect. So these are three cases that have essentially followed Parfee and said, if the claims don't arise from the agreement, they don't get covered. And the most, I think, relevant example of this is OTK Associates. There it was a deal case. And there were claims under the merger agreement and breach of fiduciary duty claims relating to the merger agreement. And the question was, does a forum selection provision in the agreement, there it wasn't an arbitration provision, pick up those fiduciary duty claims? Answer, no. All right. But Delaware has not been so concerned about other types of non-contractual claims. So Wilcox and Fetzer is our big example there. An arbitration clause extended to non-contractual claims for things like trade misuse, fraud in connection with that. Even though you could make that same argument under Parfee, that they had an independent source. So at least during that early 2000 era, there was this quaint notion that we wanted to preserve the Delaware courts as a forum for policing fiduciary duty claims. I'm not sure whether that policy interest still holds, but under Parfee you can see that animating and trying to keep fiduciary duties out of this. All right. Last example that I want to give you in terms of case law is that there are some other things that we know about arbitration agreements. The first is that if you have a claim that challenges the contract containing the arbitration clause, that is still arbitrable unless the claim directly attacks the arbitration provision itself. So this is the distinction between the container contract and the arbitration agreement. So what we can imagine then is that language extending to a claim for breach of fiduciary duty, for example, challenging the entry into the governance agreement. If there's not a challenge that the arbitral forum itself was a breach of fiduciary duty, we could envision this same logic applying. Then the last thing, and I actually think I may have the date wrong on this, I think it was more recent than 2002. If you assert a derivative claim, you run through. All right, so what we can do then is broaden our arbitration provision. We can broaden it to include explicitly these types of other claims, and we can also allow the arbitrator to determine substantive arbitrability, which is whether the claim has to go to arbitration. Most of the time, once the arbitrator decides substantive arbitrability, you never see it again. All right, so here we end up with some ideas about covered or not covered, right? Challenge the decision to enter into the agreement as a breach of fiduciary duty. Analogous to that container contract idea, you probably got a good basis to send that to arbitration. Challenge the validity of a right in the agreement or the exercise of the right of the agreement, that should be clean. That's the type of thing that you would think would go to the arbitral forum. Asserting a claim for breach of fiduciary duty, which I think is where most of the action is. If the fiduciary duties arise as a result of the governance agreement itself, then I think you're in arbitration. If they arise separately, you've got a Parfee problem that these folks are going to have to overcome. Then if you get to claims involving other fiduciaries like directors, as Eric said, that's probably the toughest one. So there is potentially something that you can do to address those, and this will be my last point. This is the stronger medicine concept. 122.18 allows the corporation to covenant that it won't do things, and it says that the corporation can covenant that people associated with the corporation won't do things, including the board, the stockholders, or beneficial owners. Now, those covenants don't bind those people because only the corporation is the counterparty, but you could use them to create enforceable rights against the corporation. So imagine that the corporation commits, as here, that various persons, including its stockholders, will arbitrate. If the corporation then breaches that covenant because the stockholders sue, then the corporation could have a remedy. Query how that plays, but it's an indirect way to get at the outcome that Eric and Dorothy are going for. So thanks very much.
Thank you. Following Vice Chancellor Laster is very difficult. Following Eric is very difficult, but I'll do my best. Thanks for the invitation, and thanks for a really interesting idea. The focus of my remarks is that I think for Dorothy and Eric's proposal to move forward, it requires a pretty aggressive reading of the 115 carve-out of 122.18. And I worry that aggressive reading is going to provide support for a very different movement to increase the scope of arbitrability in Delaware that is, I think, on the horizon. And so while I find the basic idea really, really interesting, I find myself hoping that it doesn't succeed. So as Travis pointed out and as Eric pointed out, 122.18 has this explicit carve-out for 115. So clearly it permits some arbitration of governance agreements. The synopsis, which wasn't mentioned, goes a little bit farther. The synopsis says that the proviso excludes 115 so that corporations may enter into contracts under 122.18 with exclusive form and arbitration provisions that do not select the courts of this state to adjudicate claims under the contracts. The question then is as to permissible scope, which Travis gave a really wonderful account of, really is a question of how narrowly or how broadly this under the contracts language is going to be interpreted. Whether it includes arbitration of internal affairs, as Dorothy and Eric proposed, whether it includes the arbitration of federal securities actions, including 34 Act claims for which there is exclusive federal jurisdiction, whether it could include other claims against the corporation over which Delaware does not have jurisdiction, for instance, employment contracts. But as I say, my main concern is elsewhere, because I think Dorothy and Eric's proposal, at least their broad reading of 122.18, paves the way for companies to go public with arbitration and maybe also with fee-shifting provisions as long as they're included in a governance agreement. Remember, in the Moelis case, the governance agreement was executed prior to the IPO and was fully disclosed in the IPO, and that both in the legal analysis and in the general discussion around Moelis was a really important part. Now, what does Silicon Valley want when it comes to arbitration and fee shifting? They want it. Pretty clearly they want it. When last time around, Delaware pushed back and limited arbitration in 115, and they did it in the broad way that Travis mentioned so as not to run afoul of the Federal Arbitration Act. And that was clearly on people's minds. How to structure 115 so it was not preempted by the Federal Arbitration Act. And the other piece of this, fee shifting, was prohibited in 102 and in 109. Now, why does Delaware care about this? Well, litigation, as we all know, is the lifeblood of first and most importantly, the development of Delaware corporate law, so much of which is common law. And secondly, it's the lifeblood of Delaware, of the Delaware Bar, whose interests are broadly aligned with Delaware's interest in remaining the incorporation capital and the de facto promulgator of national corporate law. Now, there's a separate question that people can disagree on, and that was very much on the agenda when 115 was discussed, which is whether, as a policy matter, mandatory arbitration and fee shifting should be permissible. And people take different views on this. I don't want to get into that now. Really, the question is Delaware's interest in this context. And as to these, as to arbitration and fee shifting, there is a surprising, not surprising, I suppose, an unsurprising unanimity, not unanimity, but broad support for limiting these within the Delaware legal and legislative communities because so much of the state's interest is at stake here. On the other hand, there are efforts to put exactly these issues on the policy agenda. Paul Atkins, chair of the SEC, gave a widely reported speech at the Weinberg Center. I was not there, but I read the speech, and he had two principal topics he wanted to talk about. One was whether precatory shareholder proposals are a proper subject for shareholder action under Delaware law, and he suggested that Delaware should say no. And the second was mandatory arbitration and fee shifting. And the SEC has said that it will no longer refuse acceleration for IPOs with mandatory arbitration provisions. 115 still prohibits those provisions, and the clear message of Chairman Atkins' speech was that Delaware should get on board. So how might this battle play out? Well, the opening skirmish, I take it, would be an IPO with a governance agreement providing for mandatory arbitration. and maybe throwing in fee shifting for good measure. Taking 122.18 as the authority for such a provision, citing to Dorothy and Eric's piece repeatedly to explain why this is entirely permissible, and that will raise obvious legal issues. Is the mandatory arbitration provision permissible under Delaware law? Will it be binding on post-IPO shareholders, assuming some sort of drag-along provision? Is abiding by the governance agreement consistent with the board's fiduciary duties? Is the fee-shifting provision permissible despite 102F and 109B? Can it be framed as an advanced waiver of rights under 102F and 109B, binding on all shareholders? Now, suppose the stockholder, the shareholders challenging it, Jaron would definitely bring this case, win this first round on the grounds that the 115 carve-out only authorizes arbitration of the stockholder governance agreement itself, and certainly not fee shifting. Suppose they win the first round. What's the second round? And here it seems to me, and this is an issue on the horizon that I worry a lot about. It seems to me it's a replay of 2025. Controlled Silicon Valley companies, through their lawyers, call the governor's office and threaten to leave for Nevada or for Texas if Delaware doesn't change 115 to permit mandatory arbitration and doesn't change 102 and 109 to permit fee shifting. Does Texas currently allow mandatory arbitration of fee shifting bylaws? I don't know, but I would expect that Nevada will change its law once they realize that this is a hot issue for the Silicon Valley companies who they would like to attract. And, you know, Ben Edwards is a good lawyer. Ben Edwards is working with the legislature, I believe, in Nevada to update their corporate law to make it well-suited for the clientele that Nevada is seeking to attract. Same with Texas. Good lawyers in Texas. So now, in the wake of this, the governor convenes an ad hoc committee to draft amendments to the DGCL to permit arbitration agreements and fee-shifting bylaws. Bill goes to the General Assembly on an accelerated schedule, bypassing the Corporation Law Council. After what we saw in a year ago in SB 21, is there any reason to think it would come out any different this time around? I don't think the Delaware lawyers want mandatory arbitration or fee shifting. I'm quite certain they don't want it. But at the point that the controllers last time around proved that a credible threat to leave Delaware is effective in getting the General Assembly to change the law, I have no reason to think it will be any different this time around. So in some sense, like bringing it back to Eric and Dorothy's paper, while I hope their proposal isn't accepted in the sense of its interpretation of 122.18, whether it's accepted or not may not matter, because the political forces are such that whether a narrow or a broad interpretation of 122.18 is given, that's only the first round. Let me stop there.
I'm really excited to be here to discuss this proposal. I have to preface this by saying I work on international arbitration, so I'm not necessarily an expert on Delaware corporate law, but I did want to discuss the arbitration aspect of the proposal from a more kind of policy-oriented perspective. And so the two things that I want to talk about are first, what does the fit between arbitration and corporate law look like? Is corporate law the kind of thing that sets itself up to be adjudicated well through arbitration? And then second, whether it's possible to move to arbitration while retaining what I consider, and I think what many other people would consider to be one of Delaware's great advantages, which is a well-developed body of case law. So for the first part, I just wanted to draw on this conceptual framework that I've developed elsewhere. So I want to draw shamelessly on what's going to be my job talk paper called The Forms and Limits of Arbitration. And the point of that project is just to say, we've spent a lot of time talking about who should be in arbitration and who shouldn't be in arbitration. So for example, unsophisticated, vulnerable consumers shouldn't be forced to go into mandatory arbitration. That's kind of been the focus of the discourse. And I want to think about what kind of procedure is arbitration fundamentally. So I think that arbitration is distinguished by two features, which is that arbitrators are unlike standing judges in two ways. So their mandate is more limited with respect to the parties, and then also with respect to the duration of the proceedings. So first, because arbitration is a product of party consent, arbitrators only have the power to adjudicate the dispute as regards the parties that sign the arbitration agreement. And second, because they're only appointed for the duration of the proceedings, they can't supervise remedies after the award. And I argue, full argument is elsewhere, but I argue that this makes it hard to, for example, grant specific performance. And so for this reason, I argue that arbitration is generally best suited for discrete contractual claims involving a limited number of parties. So, okay, there's a slide that's, oh no, we got it. So to briefly preview this argument, consider the constraints that the requirement of party consent imposes on class actions. So many people think of arbitration and class action lawsuits as mutually exclusive, if only because arbitration agreements typically contain class action waivers. But my argument is that there's like a deeper conceptual relationship between, or a deeper tension between arbitration and the collective resolution of disputes. So arbitrators have limited power, as I said, to reach parties that didn't consent to the arbitration agreement. But even when all the parties so even when you're trying to consolidate claims brought by parties that signed the same contract, it's not so easy. So even when there are multiple parties under the same arbitration agreement, different arbitral institutions have requirements such as that the parties explicitly consent to consolidating their cases, or because a corollary of party consent is that the parties have a choice in who their arbitrator is, they say that arbitrators can't have already been appointed in the previous cases in order for consolidation to happen. And these are just like different rules, different arbitral institutions have different rules, but all of this flows from the fact that you need party consent ultimately to get to arbitration. And then arbitration's time-limited characteristics also make it hard to obtain specific relief. So arbitrators can grant specific relief, but they can't supervise the remedy after the award. Then the successful party might have to go to a court and prove that the court has jurisdiction, and there might be time lag issues that are hard to resolve here. But I won't get into all of this. The important thing for the purposes of this paper is that it's at least an open question whether arbitration as a procedure is best suited for corporate disputes. So I just wanted to do a kind of brief issue spotting exercise, and again, I'm not the expert on Delaware law. I would defer to Vice Chancellor Laster and the other people who are here today to kind of flesh out what this would look like. But for like the first issue that came to my mind was also whether a third-party beneficiary can be bound to an arbitration agreement. And that seems not as clear-cut as the authors suggest here. It seems like under Delaware law, the third-party beneficiaries are bound only by the obligations arising from the specific benefit-conferring provisions. And so what does that mean if they're bringing a claim that isn't directly governed by the stockholder agreement? And then I just wanted to flag the issue of class actions. I don't really know, it's an open question to me how relevant or how many cases this might cover in reality. But if the parties subject to the stockholder agreement want to bring class action lawsuits, would their claims be redirected to arbitration? Would the arbitration clause itself exclude class actions, which is fairly common? And would the stockholders necessarily want to agree to that? And I just wanted to flag also that as a kind of development in commercial arbitration, different arbitral institutions are developing different ways to aggregate claims. So the American Arbitration Association has a set of rules that apply specifically to class arbitrations. But there, the limitation is, again, because of the requirement of party consent, it doesn't seem like an arbitral award can bind someone who didn't opt into a class explicitly, so you don't get the kind of opt-out mechanisms for constituting a class that you would in traditional litigation, or if they didn't participate in proceedings, it's unclear whether that award binds them. So there are kind of tricky legal issues that arise here. But the thing that I really wanted to focus on, and what I consider to be the biggest concern with this proposal, is whether the move to arbitration will compromise some of the public-facing features and functions of litigation. And this is something that's come up already. But there is a concern about the ability to clarify and even make the law. And so the key question here is whether arbitration can replicate these advantages, given that most arbitration is by default private and non-precedential. And this is just a quote from the paper that I thought was really beautiful. Incorporators and litigators in Delaware have the luxury of navigating their metaphorical boats by reckoning against a sky that is dense with the starlight of precedent. So what's going to happen to this beautiful sky full of stars? So I just want to start by making a distinction between the publication and publicity of awards on the one hand, and whether those awards act as binding precedent on the other hand. And so I think this is an important thing to distinguish, because just because you're publishing awards doesn't mean that they have any kind of binding precedential effect, right? So these are related but not identical concepts. And so first, on the issue of publishing awards, the authors propose giving the parties the power to stipulate confidentiality, so they can opt into confidentiality, but they would have to, for example, pay extra fees if they wanted to seal the records and not publish the award. But I think that this comes into tension to some degree with the idea that the DAB would be a for-profit business entity that would be subject to market competition, because there's the risk that another arbitral institution could come and say, we're going to offer you the same services, same fee, and you don't have to pay extra to seal your records. And so other institutions could attempt to undercut the DAB in these ways. Now, I think this problem is not insurmountable, because all the DAB has to do is offer some other comparative advantage. For example, if it has exclusive access to certain arbitrators that you couldn't get elsewhere, that might be a way to kind of overcome this challenge. But I still think this is a pretty pressing concern, given that the default in much of commercial arbitration is in favor of confidentiality. But I think the issue of precedent is more complicated still. So if the DAB's published awards are to become arbitral precedent, to whom and to what cases would those awards be binding? The DAB has no power over other arbitral institutions to require them to use their cases. And more fundamentally, I think the underlying body of law itself will fragment, given that part of the proposal is that parties can opt in and out of different versions of Delaware law and even other states' laws. And so you have a bunch of different cases that are not even adjudicating the same body of law. And just as a brief kind of point of comparison, I wanted to raise investor-state dispute resolution, which is a totally different system of arbitration, but this is arbitration involving investors and sovereign states. And in this case, you have, so this is in investor-state arbitration, publication of awards is the norm, but there's no practice of binding precedent, both because of the specific nature of international law, but also because all these arbitrators are adjudicating different cases, different disputes that arise out of different law. So the disputes that are being adjudicated come from different treaties, and so it's really hard to accomplish coherence and precedent in that system. And so I wonder if that is the direction that the author's proposal would move us towards. And just to end, I want to say that in the investor-state regime, people want to make the investor-state regime more like a domestic court. So they want to bring it into a kind of binding system of appellate review, and it seems like this proposal is moving us in the opposite direction. So I'll end there, and looking forward to discussing.
So thank you so much to Dorothy and Eric for this very exciting paper. When Eric first called to ask me if I would do this, he said that I was invited to give 15 minutes of roasting comments. And I was both delighted and flummoxed, because I do love to roast Eric. But how could I do that when Dorothy's also on the paper? Fortunately for me, Eric also told us yesterday that when he said 15 minutes, he meant 8 minutes. And so I had to drop most of my roasting comments and leave only compliments and some questions that I'm sure they're going to answer, and then I will thank you for the trip to New York. So anyways, more seriously, I think this was such a fun and interesting paper that brings together so many important strands of literature, and unlike what we do a lot, it also provides a very real potential solution that I think is provocative and bold, and has led me to contemplate a few questions, which I'll just outline here. So my first question is, what does the DAB do that existing arbitral forums cannot do? So last night at dinner, Vice Chancellor Laster described the thing that the DAB is doing as going for Delaware 1.0, which I think is a nice shorthand. And if Delaware 1.0 is what the parties want, why use the DAB instead of something that already exists, like JAMS arbitration or AAA arbitration? So it is at this point in preparing my remarks that I was going to say, surely there are many retired Delaware judges who are available as JAMS arbitrators, but my crippling fear of being unprepared, which is a trauma response from having been Saul Lovemore's student, caused me to log into the JAMS website at 11 p.m. last night to confirm, and bad news for me, there is one JAMS arbitrator that is listed as having Delaware experience, and unfortunately for us, he is a federal judge. But good news, he does travel, so if you are looking for a federal judge who happened to live in Delaware to do DAB-like stuff, he could come to you for a small fee. And I watched his video, he seems very nice. But I do still worry, despite the lack of backup for my own idea that you could just use JAMS arbitrators, that JAMS is a well-established organization, or AAA. They could add retired vice chancellors to their docket, and then suddenly Bob's your uncle. They just have eaten the DAB's lunch. Speaking of direct competition to the DAB, that leads to my second question, which is, what about Delaware itself? So in a paper with Dave Hoffman, Matt Genejon, and Dave's student, Luisa Pedroso, that is perennially a work in progress, and which Eric has already commented on like last year, we explore the instance of arbitration and M&A agreements specifically over a 20-year period from 2000 to 2020. And we also interviewed litigators. So we found that parties over this period hold steady at choosing whole agreement arbitration at about 8.4%. It's a very strange number, 8.4%, but over this 20-year period, about 8.4% of all publicly filed M&A agreements elect for whole agreement arbitration. And we also find that parties choosing Delaware law or seeking ultimate enforcement in Delaware as a dispute resolution forum are significantly less likely to pick arbitration, while other jurisdictions are more likely. So the findings in this paper, which I should just point out now is called Mergers and Arbitrations, we're very proud of that, have a couple of suggestions, like a couple little Christmas ornaments to kind of hang on the Dorothy and Eric tree. So first, Delaware seems to be the forum of choice even when parties can choose arbitration, like Delaware courts. Can DAB compete with the overwhelming star power of real Delaware courts? Or is DAB going to only get set up and go through all this process only for Delaware courts to eat its lunch? Second, before you can say, well, your findings end in 2020, that's Delaware 1.0, things are very different. Here in the world of Delaware 2.0, there were very significant changes in that time, 2000 to 2020 as well. So the first is, in 2009, the Delaware Chancery Court made a foray into private arbitration via a statutory amendment that allowed chancery judges to sit as arbitrators in private disputes for $6,000 a day. $6,000 a day. I would hire a Delaware judge to just mow my lawn for $6,000 a day. That would be fun. Could we? That's fun. A subsequent federal lawsuit gutted that arbitration experiment very quickly, but I think in that time period that it existed, there was one dispute before it was gutted. An adjusted version of that state-sponsored arbitration remains available through a 2015 Delaware Rapid Arbitration Act, which established a Delaware-seated expedited arbitral forum with some chancery involvement and limited ability to appeal to the Supreme Court. Despite these changes and opportunities for various types of Delaware-adjacent arbitration, parties consistently chose arbitration at about 8.4%. which is to say it's possible that real Delaware courts are so preferred that even Delaware adjacent arbitration doesn't really hold a candle to like real Delaware courts. Parties seem to have like an overwhelming preference for them. And as a side note, even if parties like arbitration, there is the Delaware rapid arbitration, which is maybe going to be their first step instead of the DAB. I'm not sure. So, which is to say, I would love to see in the paper some discussion of how the DAB stacks up to Delaware rapid arbitration, or if there's a world in which the DAB just hops on to like an existing infrastructure like Delaware rapid arbitration, lowering the cost of establishing the DAB. So, my final question today is that part of this paper is based on this idea of jurisdictional competition and the downstream effects of that on Delaware, which could lead to something like the DAB really having a place to shine. But I wonder if it's time for us to angst about it yet, or if we could just wait a second before we take such a drastic step. So I already told you I was working on this presentation at 11 last night, so you know that inside of me is a person who was perennially doing her Spanish homework in math class. But like maybe we could all just procrastinate a little bit. And in thinking about the procrastination idea, I was reminded of another paper, and I'll just quote a little bit from this other paper's abstract. From a practical vantage point, I will argue that while this trend is certainly a cause for concern, aspiring reincorporators already face several constraints that may decelerate the trend naturally without significant regulatory interventions. These transactions introduce material downstream legal risk since they move the locus of corporate internal affairs out of conventional jurisprudential terrain and into the domain of foreign jurisdiction whose law is by comparison recondite and unfamiliar. Does this argument sound familiar to anybody? Yes, it should sound familiar to one Eric L. Talley. Because this is a snippet from his paper, his 2015 paper in the Virginia Law Review. I was a little sneaky here, and it was actually a paper about corporate inversions. I changed out words like inversions to this trend. But I think 2015 Eric was onto something that I think the DAB is very cool and could solve a problem, but I don't think that we need to like stand up this whole infrastructure maybe just quite yet. There could be some ways to achieve similar purposes by seeing how SB 21 plays out and seeing if existing arbitral fora could be a place where these kinds of interventions could be appended to. Those are my comments. I want to emphasize how much I enjoyed reading this paper and thinking about this idea. I have many roasts. Find me in the lunch with my Eric Talley voodoo doll, and we can stab it together.
Okay. Let's see if I can't throw a wet blanket on all this excitement. Here's what I think. One take on what the paper's really doing is that it's establishing a kind of end game to the shenanigans we've witnessed and participated in the last 2 years. This is all laid out in the paper and explained in the presentation, but I'm talking about between MOLIS and 122.18 and SB 21 and all the processes, Elon Musk's pay package, the tweets. And one way to characterize all of this is you've got a lot of senior people each trying to do each other's job and not really succeeding at it. So, you know, in no particular order, defense attorneys drafting statutes and just handing them over to the legislature, bypassing the usual processes, protecting their clients' interests as they should, but still breaking some conventions. Legislatures, for their part, quickly drafting those things, responding to the pressures that they're designed to respond to. Sitting judges watching their decisions being overturned almost as fast as they can write them. So they can't just sit there, they have to speak up. And at the same time, former judges being summoned by the legislature to testify. And if the legislator summons you, you should go. You should rightly go and speak your mind, even if that means criticizing sitting judges. And then, of course, academics, and I include myself here, each taking their own position, maybe somewhat overwrought. But in each case, I see an actor who has, in their own understanding and in good faith, tried to protect the very institution of Delaware, but each intervention is sort of by design inescapably drawing down on the trust that on the very institution that they're trying to protect. So there's this kind of mechanical downward vicious cycle here. And so the DAB, we're calling it the DAB, the Delaware Arbitration Board, the Lund Talley proposal, the DAB, is, I think, just the next step in this sequence, possibly the final step in this sequence, because now we have now we can say with a straight face that a plausible way to protect this institution is to contract around it. So here's the main point that I want to make. I have one slide. Delaware is very famously conceptualized as a product, and I think that feels right because it's selling something. There's franchise fees, and the paper draws on that tradition. It's literally redesigning the product. I mean, it's trying very hard not to describe chancery, but it basically reconstructs it from first principles. And this conference is kind of a product launch, if you will. But the Delaware as product analogy, even though that was true enough 40 years ago, I think it has since become something else. I think it is better conceptualized as a standard and not a product. And this is what I mean, because a product is something that you design and then you can hand to someone, and its value comes from being able to sell it. But a standard is something that you share, and the value comes in the sharing itself. So it's in this sense that I mean Delaware is a standard, not a product. One of the pushbacks the paper offers, rightly, is that, oh, okay, well, that might be true. There's some benefit from all using the same rules, but look at the corporate world. It's not a one-size-fits-all governance solution. But even here, I would say, yeah, but a standard does not mean uniformity. It doesn't mean the same rule applied everywhere. So for example, the gold standard, and I mean the actual monetary system of the gold standard, you might say, oh, that's just a fixed conversion rate of bullion to paper, to which I would say that's the least interesting part of it, because it's a whole ecosystem of conventions, or was, rest in peace, of convertibility commitments and settlement practices and expectations about monetary policy. You know, each country that adhered to the gold standard had very different internal practices, like fiscal positions, rates, reserve levels. So this wasn't like some shared rule applied everywhere. Instead, it was a set of conventions. Okay, so this is how I think about Delaware as a standard, not as a product to be reconstructed. And what do I mean by this specifically? You know, it's a set of conventions. There's doctrinal conventions, the prongs of MFW, entire fairness, business judgment rule. There's a practical conventions, like what does market mean for a deal lawyer? I don't know, but apparently the deal lawyers know what the market will bear versus not. And so I don't think it's a list of rules plus chancery. It's a whole set of conventions that that together produce a tremendous amount of trust. And this is something that no expert can bring. In fact, I'd say expertise is cheap. There's thousands of lawyers with really deep knowledge of the law, perhaps even deeper than chancery. But they'll never have that trust which converts one person's opinion to a declarative, authoritative statement about what the law is, or let alone what is just. So final point is that the thing that is valuable, I'd say, that this paper is kind of contracting around about Delaware is not any particular feature of the product, which can be carefully sort of re-specified, but the fact that it became a standard. So that's a harder thing to reconstruct. So just like the gold standard, and by the way, by analogizing Delaware to the gold standard, I don't mean to praise it at all. What I mean to say is that it's a genuinely accurate analogy to say it looks like a rule that applies everywhere, but is really this complex set of conventions that goes way beyond legislative actors or any particular, or is beyond the control, really, of any particular person. So the fact that this standard has, and the conventions that underwrite it have eroded and lost trust in the last few years, I would say that's exactly what gives rise to the DAB. Like, enter the DAB to be the final step in this sequence. So I guess this is to say I take the dab, I'm going to call it the dab, very seriously, but not literally. Like, it's because the solution is not to privatize the corporate law. The solution is to find a way to restore the conventions that made the standard so powerful in the first place. Thank you.
Time, so I'm just going to be really brief, thanking again everybody for the great thoughts and comments that are going to make the paper much stronger. And I'm just going to also shout out the Journal of Corporation Law that is publishing our paper, and also responses from each of the people sitting up here. And we have Asia Pinto here today from the Journal of Corporation Law, and is working hard to get our paper in good shape. So let me just say a couple of things. I think our first two presenters spent some time thinking about the breadth of 122.18. Does it override, Part B in some of these other cases? How does it interact with 115? So this is obviously a key question for us, right? How, we view it as a broad intervention, but this is unresolved. I think some additional support for why we view it as a broad intervention is the fact that 122.18 explicitly overruled Moelis, right? And Moelis was a case in which a really smart judge came out and said, how can you do a shareholder agreement that does all of these crazy things when you have 141A, right? 141A is at the core, it's a statutory intervention, but it's also the core of Delaware corporate law. This principle of board centrality, and this violates 141A. And the legislature came out and came up with this response. And so if it's going as far, if 122.18 goes as far to override 141A, which again is at the very core of our understanding of Delaware corporate law, well, maybe we think it also did some work on some of these less central statutes as well, such as 115 and 102 and all of that. So is this good or bad? That's another big theme coming out in a lot of these comments. I think Eric and I both agree that this isn't our preferred state of the world. We're not writing from a place of like, this is so exciting. We're so excited about all these developments. This is a paper that came out of a really bad period in Delaware corporate law, in our view, in which we saw partisan politics, or interest group capture, I should say, not quite partisan politics, interest group capture really infiltrating. And it led us to think about, what's the path forward? If we are forever locked, and maybe we need to be cautious and wait a little bit, like Kathy advised us and old Eric advised us. But if we are locked into this system of interest group capture, what's the path forward? And maybe this DAB idea is one possibility. And again, taking Sarah's point that it's a little funny to say the thing that's going to save Delaware is contracting around it, we do kind of think that this is a possible way, in Ed's articulation of, well, we could get just back to another path of exit. This is a way that Delaware could actually credibly allow, by endorsing this broad view of 122.18, could provide a pathway to keep companies within the state via this, via the DAB. So I'll stop there. Eric, do you want to jump in too?
No, I think, you captured most of what I was going to say. I want to thank the commentators. It was a really good and broad set of incredibly helpful comments and challenges. I think, like Dorothy said, I don't think we have not set ourselves up as like romantics about this particular solution, but it does seem to be, to us, to be a plausible exit route. And then there's a question of whether it is a good exit route, right? Or a desirable exit route. To even get traction, it's going to have to overcome some of the challenges that VCL and Ed laid out for it. And in addition, it's going to have to be able to marshal one of the hardest things to marshal, with which Sarath noted, as did Kate, like the idea of network externalities, right? A lot of us I think a lot of corporate law professors lean in the direction of saying, yeah, this race has not been like apocalyptically bad and has probably on average been good, but the first order effect is, just sitting on this panel is probably a group of 5, you include me, or you include Dorothy and me, 7 people who have collectively taught, I'm just going to say, rough estimate, 100,000 corporate lawyers. And they have largely learned one area of law, and it's Delaware, right? And so to be able to pull this finesse off, even to make it work, we're going to have to, and it's very the paper is very self-conscious about trying to create a set of institutions that essentially kind of mirrors a lot of the institutions that we see in Delaware, not just the expertise, but also the convention. And then, I think the real question is, to the extent that the DAB can enter, that JAMS can set up its own wholly owned subsidiary, that Nevada could move in this direction, what's competition going to do when there are private actors involved? Is that going to increase or decrease some of the dangers of racing to the bottom versus the top? That's one that is very, very difficult to test. We are, pitching a potentially optimistic tune here that in fact, competitive capital markets have kind of selected Delaware in part because of its predictability and the fact that it is not systematically squandering resources and by some accounts is actually, creating value. And so, this is a way forward. I don't think either Dorothy and I are, especially ecstatic about it, but by the
Although
same.
we are willing to serve on the DAB, right?
Yeah, we will. Yeah, indeed. So, and that's all I got.
All right, I think we actually have time for, believe it or not, we may have time for a question or two, depending on how long-winded we all are in answering. If anybody has thoughts they want to share, suggestions, criticism. Oh, yeah, Gabe.
Extremely interesting. And I had 2 quick observations. One is I think the DAB is a cautionary note for where state competition will lead if it's a race to the bottom, which is low fees for all the states. So Delaware dominates the market for statutory partnerships for investment funds, but makes no money because alternative entities don't need the courts that much. So the thinner the product becomes, the less any state is going to make, because you're not going to be able to charge a lot of fees for offering the product is maximal contractual freedom. So I think that there's, this is not an argument against the paper, it's just if the road leads to the LLC, all the states are not going to make a lot of money from the product they're selling. That's the first observation. And then the second one, really quickly, is maybe the paper engages with this, but I think the most plausible place for this to begin would be with unanimous shareholder agreements in private companies. So you might want to just think about, the NVCA might be the most plausible constituency for turning the DAB into a reality, where they're like, already Manti and New Enterprise give us a lot of contractual freedom within corporate law, maybe give you a setting where you're allowed to have unanimous shareholder agreement, you can face none of these problems with third-party beneficiaries, and you're just genuinely opting out of all of corporate law without any problems there.
I see another hand from Lucian, so I want to just make sure that we collect comments first, so with the time we have.
I'm glad, Dorothy, that you qualified that you're not excited about this privatization, but rather just showing that this is what's going to happen. And I just want to reinforce what I think Sarad was going, that this would be really the last act of Delaware. This would be like the end. Because what would happen, essentially, is I think that you are trying to make it attractive for Delaware by saying DAB, but it would be the Delaware arbitrators who would be sitting in. But there's nothing conceptually why it has to be DAB. You could, with the same thing, you could have the Wachtel-Lipton Board of Arbitrators that would send to the top litigation partners at Wachtel, and you could have another one that says the Columbia Law School Board of Arbitrators, where the senior corporate faculty, and you would have another one that says it's the Steve Bainbridge Board of Arbitration, if you like his view. And this is all the more dangerous because you're allowing the DAB or the others to change also the law, not just to adjudicate on the basis, which means that you're really allowing practically private contracting. And to end this, Delaware would allow somebody to say, I am contracting to get the Nevada Board of Arbitrators and the Texas Board of Arbitrators, and maybe not even the Nevada Board of Arbitrators, but you mentioned the person who is now helping Nevada to legislate even more aggressively. So I think that some companies might say, you know, let's go to this person. So to me, this sounds like, I would suggest to you to go farther than what Dorothy said and say, this is not really something to be excited about. This is a warning call that the kind of things that the statute allows, they might lead to a situation in which everything is possible and everything is open.
Yeah, these are great comments. There's one common thread between Gabriel's and Lucian's comment that I think is worth taking on. So I do think that if you take this proposal and then you try to evaluate whether it's desirable or not, a lot of that, Lucian and Gabe, is going to hinge on how well you think regulatory competition is going to work when there are new, potentially private actors in the game as well. This is not a new field. We've had regulatory competition for over 100 years. I think there's a general sense that while it doesn't work perfectly, it's worked okay with public providers. And so the question is whether private providers that, like Delaware, that wants to pave its roads, are also trying to earn return for putting out a valuable set of products and conventions, would have value destructive incentives, Lucian, or would be in a position where, say, like, capital markets are actually going to price in quality on average. We don't know the answer to that question, and as you know, these kind of differentiated product competition models are a little bit complex, but it's not impossible. I still am a little bit queasy, and Gabriel, to your point, one of the reasons why I guess one could be very queasy about this, to the extent it takes off, there's nothing that prevents North Dakota saying, well, we're just going to have as permissive a stockholder agreement statute as Delaware has, and you can pick Delaware law, right? At the end of the day, if you take that to its natural conclusion, the states aren't really providing much other than limited liability protections and enforcing and compelling arbitration and enforcing arbitration orders, right? You're not going to be able to make bank to pave the roads in Delaware if that's the competitive market you find. And if your objective is maximize the welfare of Delaware, this is unambiguously going to be bad. If your objective is maximize value for the provision of corporate law, we've got a more interesting conversation to have.
All right, well, with that, let's break for lunch. We'll see you back here 12:25.